All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Okay, we are here for oral argument in case number 1CACV 20-0545, University Medical versus Health Choice. Council, as you're probably aware, we record and live stream the proceedings, so please give your name and the name of your clients when you begin your arguments. According to our current protocol, each of you will argue from your council table, obviously, and each will have 20 minutes per side, although you're not entitled to use all of it, but I assume on this case you probably will. We do require you to keep track, appellant's counsel, of your own time and reserve as much time as you need for rebuttal. I believe you'll be able to see the clock while you're arguing. If not, you can sort of move over a bit to see it, but again, you need to watch that and reserve what time you need. Please keep in mind that we've read the briefs. We're generally, I'm not going to tell you we've read every page of this record, but we're generally familiar with the record, and we've discussed the case in conference. With that, counsel for appellant, you may proceed.
Thank you. My name is Robert Cathcart. I'm counsel for Health Choice Arizona, one of the appellants that's on this case today. We are a contractor for Access. Now, Access and the director are represented by their own separate counsel, which is Logan Johnston. Mr. Johnson was intending to be here today. Unfortunately, he was not able to join us today because of a difficulty that arose getting to the courthouse today. So the good news is that before that, he had agreed that I could use all of the appellant's time. So I will be the only one that's arguing on the appellant side of this case today. Before I get into that, I would like to reserve about 5 minutes of time for rebuttal. And if I don't need all of the time on my presentation here, then I'll happily reserve any remaining time for the rebuttal there as well. So with that, if I may please the court. This appeal, I think, as you know, you've read the briefs.
Counsel, could you pull that mic just a tiny bit?
Yes. So this appeal involves a hospital and its professional billing company that didn't comply with the applicable rules, the applicable statutes, the applicable billing requirements when it submitted multiple claims related to inpatient hospital services provided to a member of Health Choice Arizona.
Counsel, which statutes?
Which statutes did it not comply with?
Yeah.
So it didn't comply with the statutes that involve that a provider must...
Do you have a number?
So there's ARS 3629-03.01A, which requires a provider agreement. There is 2904D, which requires a provider agreement. 3629-04D, as in dog.
2904D, okay.
There also requires a provider agreement. There is Arizona Administrative Code R922-714.
Wait, administrative code?
Correct.
Okay, so what's the statutory basis for that?
The two statutes that I just mentioned are the statutory basis for the code section.
So that's the universe, those two statutes you gave me.
Well, so those are the two code sections that give rise to the need to comply with the provider agreement and the need to comply with the billing requirements. And then in addition to that, there is the statute that is talked about at length in all of the briefing that was certainly talked about below, which is 2904G. That statute applies to whether or not there is a timely claim.
So these, the first two statutes, the provider agreement, was that reason initially provided to UMC as the rationale for denying any of the three claims?
So was that one called out specifically? No. Is failing to comply with the provider agreement and the billing guidelines? Yes.
Right. No, I think I'm just asking was it given as a reason?
So was that statute cited? No, it was not cited.
Okay, let's back up. Was it paraphrased? Was that a reason given for denying any of the three claims?
And I'm sorry, so in the director's decision, yes, it was. The provider agreement was in the director's decision.
The initial denial, three claims.
Okay.
Was the billing guide or these two statutes, was that provided as a reason initially for denying the three claims?
I'm having some difficulty answering that. The statute was not cited. They were told the first claim was denied for being untimely. The second claim was denied because it had more than 30 days on the interim claim.
Okay.
Both of those.
Compare that then to this third deficiency. So we have untimely. The second one was what?
An interim claim that billed for more than 30 days.
And then we have this third the director's rationale after the ALJ decision, right?
I don't agree that was the director's rationale. I don't agree that.
Did the director have a rationale?
The director did have a rationale.
Okay. Was that the same rationale offered earlier in the process?
All of these are failure to comply with the provider agreement and failure to provide with the billing guidelines. Does it say you didn't comply with this section of the provider agreement? No, it doesn't say that. But all of these are because these are requirements in the provider agreement. These are requirements that are in the billing guidelines, and you don't meet them. And
so is there a process to fix an error? Or once you submit a bill, is that set in stone to be either approved or denied?
Yes, there is a process to fix the claim. And that is what happened with the notice of decision that was given to them. And that is one of the things that I was going to really focus the crux on this today with my argument, was on August 12 of 2017, they were specifically told, we cannot process your claim as billed. You must bill everything on one claim form with all dates of service. And they didn't do it.
And how long?
You just said that the claim was denied.
This was in the claim dispute process.
Okay.
So the claim
At what
dispute
point did
process.
you deny the claim then? Did your client deny the claim?
So there's three different submissions here. So let me, if I could, take them in order. The first one was in March 31 of 2017 is when the first set of claims was received. On that one, there was two claims that Health Choice has record of receiving. The third one, no record of receiving that. Those two claims were denied on April 14. The call logs from from MedData show that they talked with the claim representative, and the claim representative reported that claim number 1 was denied for being untimely. And that makes sense. It was for services that ended on September 1st, and it was received on March 31st, more than 6 months later. Under 2904G, that's not timely. The second claim was for services that were within that 6-month time period, but it was an interim claim. It was an interim claim that included more than 30 days of dates on it. That isn't payable. An interim claim can only have 30 days on it. They were told, can't bill an interim claim more than 30 days. The third claim, no record of receiving it. The third claim is the one that they say gave notice that there was a discharge. We didn't have that. We didn't know that they shouldn't be serving or that they shouldn't be submitting interim bills. On the third one, because we didn't know that there was a discharge, we handled the first two groups like they were interim claims. The third one, no receipt. So then they, in their briefs here at this court, they include the representation again that Health Choice advised them to break the bill up into 30 days. Down below at oral argument, opposing counsel correctly advised the court down there, that's not right. It's in the brief, but it's not right. Instead, what it was that the representative from MedData, from UMC, said, I'm going to break this bill up into 30-day increments, and I'm going to resubmit. So this is the second set of submissions now. This happens in May of 2017. In May of 2017, they submit 7 interim claims, including the one that shows discharge. At that point in time, the denial, when they call in and they ask, has this claim been paid, and it's denied, the reason that they're told that it was denied was because it was untimely. Now we know that it's post-discharge. Interim claims submitted after discharge, by definition, untimely.
What do you mean by definition?
I'm sorry?
What do you mean by definition?
An interim claim under the regs, under everything that we
reg?
got,
What reg?
R22.712.76. And this is A, B, and C. Interim claims.
They were told that?
They were told at the time that they were untimely. Now, as far as the rationale for why, we don't have that phone call. We don't know. We've got their call logs where they wrote it down. Now, what we do know is that they immediately then sought the claim dispute process, which is what you do if you think that there is an improperly denied claim. Now, before that process that starts in July of 2017, there's no statute, there's no regulation, there's no rule that requires an access contractor to explain in detail or explain really any rationale for denying the claim. If, for example, somebody were to send a claim to the wrong payer, the wrong payer doesn't have an obligation under the Arizona Code to respond back and say, well, you submitted it to the wrong person, or that person's not a member here, or whatever it is.
You're not the wrong payer.
What's that?
You're not the wrong payer.
But I'm using this as the example, right? There is not a regulation that requires that sort of a denial to get done. It's the provider. The provider is the one that wants to get paid. The provider is the one that needs to show and needs to comply with the billing guidelines.
But you do give an explanation. You say we're not obligated to, and yet you do, and you did in this case multiple times. And the same reason you gave under the first claim of untimely, meaning that it was more than 6 months, is the same word that you use later to denote that it was untimely because you saw it as an interim claim instead of final. So do you take on some obligation when you do exceed what you say is your obligation to, that you have no obligation to tell them a reason, but if you're going to tell them a reason, do you have an obligation to have that be a reason that can be corrected or is truthful or gives guidance if you're going out on a limb to do that?
There's nothing in the regulations that say that. I mean, what we're really, I think what it comes down to
you
is...
are doing it. And when you do it and you take on that, do you have to give them something that is meaningful? You're saying I don't have to say a word. I can just say denied. But when you do say a word, what's your obligation there?
So,
Be accurate.
yeah, so in these instances, these are phone calls that are made in by the provider to the claims department. They're asking about the status of the claim. And they're told it was denied. What's the reason for the denial? It was untimely. What happens in that phone call, we don't have records of that phone call. I don't know. What I have is I only have their notes. I don't have anything else for that shows that. Now, as far as going through and telling them what they need to do to correct their claim, essentially we're saying that we've got to be telling them how to do their job, how to comply with the billing requirements. If that's the case, then it shifts the burden to Health Choice to be the one to explain, here's all of the reasons why you shouldn't get paid. Instead, the burden here is on the provider. It's the provider that needs to comply with the billing requirements. And the only way that we can process the claims for all of these access members, there's 1.8 million access members. There has to be an automated, efficient process to be able to process these claims. And if every time that one of these claims gets denied, that there needs to be a thorough explanation of here's what you need to do to correct the claim, we're going to just completely bog down the system. There's no way
Thorough?
that you can process
How
all
thorough
those claims.
would that have been? Let's explore that. What is a thorough warning? I mean, wasn't it just like a sentence?
Well, here it was, the claim was untimely. Now,
But nothing about miscoding.
but we don't even know that it's miscoded. They submitted an interim claim. An interim claim is a claim for, please give me $500 a day for each day that the person's in the hospital.
But you said it in May, that's when you knew that there had been a discharge.
Correct. Now, did they say, well, it was untimely? Why is it untimely? Well, because it was an interim claim. If you're post-discharge, you've got to submit a final claim with all dates of discharge and things like that. That was done on August 12th. That was done on August 12th. On August 12th, in the record, it's the record 23, exhibit number 9. They were told, we cannot process your bill as done. You must submit a corrected claim billing all dates of service and charges from 6/5/16 to 1/5/17 on one
That's
claim
an
form.
August notice?
August 12,
That's
21
why
of
you're really
2017.
confusing me, because I thought you couldn't resubmit after 6 months after discharge. That discharge would be June 4th.
And this is where, again, that there's some disagreement in the record on this one. I apologize, I'm about to run out of my time. But this is where we've got some disagreement in the record. They're saying that we wouldn't submit a corrected claim. There is nothing in the record to support that. The record that's there, their claim notes, is exhibit number 10 to record number 23. Their claim notes say that the person told them that they wouldn't accept a second level appeal, which means an appeal of an appeal. Okay? They didn't tell them that they wouldn't submit a corrected claim. And in fact, the person that wrote the note said, I'm going to submit a corrected claim. That person thought that they could submit a corrected claim. The problem is they never did it. Unlike every other example in Exhibit 10 to record number 23, where they submit a claim, on every time they submit a claim, they've got a USPS mail tracker. For the March ones, for the May ones, they've got a USPS mail tracker. For the October one, not there. They've told you in their briefs they can't find it. They don't have a copy of the claim getting submitted. They don't have a record in here that it got submitted. We have no record that it was ever received. That's the problem. And that, to me, is the linchpin of this entire thing. We don't have to worry about whether or not an interim claim is an initial submission of a final claim. The question is, did they ever correct their claim? Did they ever try to get that clean claim in once they were told on August 21 of 2017, this is how you got to do it? And the answer to that is no. They just didn't do it. They had time to do it. They had, as they'll tell you, they had 5 months to do it, 4 months to do it, and they didn't. And if they had, I think we're in a much different situation right now. And with that, I'll try to reserve the rest of my time. Thank you.
Morning, Your Honors. Chris Mack on behalf of the Applee University Medical Center of Southern Nevada, which I'll just refer to as UMC for short. May it please the court. Your Honors, there's one issue before the court, which the appellants didn't really address. Under ARS 36-2904G, there is a two-stage process to submit a claim. The first part of that process is just submitting the claim. You have to initially submit a claim within 6 months of discharge. We're talking about final claims. The statute addresses claims that are submitted after a patient has been discharged from the hospital. You have 6 months after discharge to do that. That is the only issue before the court. It's the issue that the parties stipulated to before the ALJ. It's the only issue that the Superior Court addressed in its ruling. It's the only issue that's before the court. Appellants have conflated the issue and are talking about the second stage of the claims process, which is that your claims must reach clean claim status within 12 months of discharge. What that means, as the statute defines, is that the contractor needs to have all the information, all the documentation that it needs to process the claim. As to the first question and the only issue before the court, I think the appellants concede, and the record is certainly clear, that UMC submitted its claims within the 6-month window after discharge. They did that in March.
But they were improper because they were labeled interim claims.
They were improperly labeled as interim claims. You are correct, Your Honor.
So the denial of those claims was appropriate, right? In April, where they said one is untimely and the other one billed more than 30 days. What was wrong with that, those two responses?
There's nothing wrong with the initial denial. They should have been denied. Now, the reason for the denial was not actually given, but the only question before the court is whether we actually submitted them. We had, well, the claims were initially submitted in March.
But being that they were improper, as you acknowledged, I mean, improperly labeled, wasn't it your client's obligation at some point within the ensuing 12-month period, the subsequent period of 12 months, within 12 months after discharge, why did you need to submit a clean claim?
We
Why
did,
didn't you?
We didn't because we weren't given the notice. We never were given meaningful notice that the actual problem with the claims was that there was one digit wrong, right? And these multiple pages of claims, hundreds of lines, one digit was wrong. It's clear from the record that Health Choice treated the claims as final claims. And in fact, they knew that patient had been discharged. I want to point out, it's interesting. So appellant's counsel noted that Health Choice submitted no information about any of the claims. I'm not sure what happened there. Apparently they have no notes. They're relying on UMC's contractor's notes, med data. Well, let's look at the notes, which are in the record. I'm looking at a note from January 11th, 2017.
Can you tell us what you're looking at? From the
Yeah,
record?
yes, and I'm trying to remember what the record
Or
site
even
is for
just
that.
a document or?
Yeah, so it's tab S that was attached to the request for a state fair hearing. It's all of the call notes. Entry from January 11th, 2017 states that MedData had submitted updated clinicals and just discharge instructions. So 6 days after discharge, the discharge instructions were submitted. That's what the claim notes provide. Now, we also know that, and as the ALJ found, all 3 claims were submitted in one envelope. The ALJ found that Health
That's a
Choice.
factual finding.
Yes, and I would direct you to the ALJ's findings. And there's
That's finding number 5, correct?
finding number 5, and there's a footnote. The ALJ did note that Health Choice indicated it did not receive Claim 3, although the claims were all included in the same envelope. She found that the claims were all submitted. She found that that MedData, the vendor, had received verification that they were delivered. And Claim 3, as counsel for appellants acknowledged, lists one of the fields on the claim type is the patient status code. Status 3 means discharged. Claim 3 had the discharge status, or the patient status as discharged. There's multiple instances in the record where it shows that Health Choice knew that patient had been discharged. The medical necessity review, which was submitted in April of 2017, stated that she had been discharged. The claim dispute stated that. Even the claim dispute decision from Health Choice acknowledged that the dates of service, again, that's a term of art under the statute, which is defined as post-discharge. It included the dates of service, all of the dates of service. Yet in its decision, it cites section 36-2904G, which only talks about the initial submission of a claim, post-discharge. We're talking final claims here. We're not talking interim claims. There's no reference anywhere in their claim dispute decision that the problem was you got to change the code 112 to 111.
What's your authority for the proposition that they have to do that?
Yeah, that is Access's own regulations, which that is R9-34-405.
And what it says,
It says you have to provide the legal and factual basis for the claim. Even backing up before that, Article 2 of the Access regulations says, okay, a notice of action has to be sent out. So we're talking
I'm talking about the
claim
phone call that
dispute.
didn't happen that said, you got to fix this number, the coding. What's the authority that phone call had to happen?
Yeah, so that's R9-34-405.
And that says,
You have to provide the factual and legal basis for the denial. Factual and legal basis.
At what point? But that's triggered after there's a request for a formal dispute.
So that's the claim dispute response regulation, but I'm going to back up even. We're now getting into a territory. I'll point out that this is going into the clean claim status question, which is not before the court. The only issue is whether there was an initial claim that was submitted.
So explain to me, like, big picture, I mean, this is a lot of weeds here.
Yes.
Big picture. Where did the director go awry, or in your opinion? What's wrong with the director's decision?
She conflated getting to clean claim status versus within the first 6 months, you just have to get a claim on file. You've then got 12 months from discharge to get everything right. Now, there's problems with both stages of that process, meaning Health Choice did not provide the actual basis for its denial and should be stopped for that reason. It didn't comply with its own regulations. If we don't know that the claims are mislabeled, how are we supposed to correct them? You can't. Everything that we had heard was that the claims were untimely. And
right. But as far as that being informed of the correction, that's the administrative code you just provided to me. The
correct.
Authority.
Yeah, well, and 2904G talks about clean claim status as well. It defines it as a claim is clean if it requires no additional information from the provider. Now, my point on that is, even though that's not an issue before the court, UMC did that. They're claiming that these were interim claims, which to me makes no sense. An interim claim is a claim submitted during the patient's stay. The patient was there for 7 months. Health Choice was constantly receiving updates. There was no interim claims submitted during the 7-month stay. The only claims that were submitted were post-discharge. By definition, they cannot be an interim claim, not to mention the fact that Health Choice knew the patient had been discharged. But even setting that aside, changing the claim type number from 111 or from 112 to 111 is not a clean claim issue because Health Choice already knew the patient had been discharged. That's not additional information. That's a clerical error. But beyond that, they never told us that. They never told us to change the claim type. Yes, it continued to be a problem throughout the process because Health Choice never told MedData, the vendor, to change the claim type.
When did that first come up? Clear at the ALJ hearing, or was it
So
before that?
there's a remnant of it in the MedData's call notes as to claim 2. If you remember, the initial claims were broken up into 3. We're talking a 7-month stay. So vendors trying to be helpful and breaking it into 3 chunks. In one envelope, it goes off, right? Now, Health Choice, the way that the statutes are supposed to, or the way that the regulations work, is they require Health Choice to submit a written decision in response to the initial claims. They never did that. There's no written decision as to the initial denials. The vendor, MedData, had to call in and say, what's the status of the claim? You have two representatives talking to one another. The Health Choice representative says, okay, well, claim 1 is untimely. Claim 2, again, these are call notes. So there's some reference to interim bill needs to be broken up into less than 30 days. An interim bill, right, has to be submitted during the patient's stay, and it can only cover 30 days. Claim
Is there anything different between an interim claim form? I mean, are the forms different, or is it simply coding? You're all using the same form?
One digit, Your Honor.
Okay.
One digit on the claim form.
No, right, but it's the same claim form?
Yes.
Okay, for whether you're interim or
It's
final.
called a UB04 form.
Okay.
Yes.
What evolves in that process of interim to final claim? Other than the number, the coding number, how does the claim evolve?
Well, if you submit an interim claim, the contractor, in this case Health Choice, still has to respond. And
Right, qualitatively or quantitatively, what's I mean, do we say, is it the doctor going back and saying, oh, I don't actually think we should charge for that? Or
no, it's just verifying that to my understanding, it's just verifying that the patient is still in the hospital, right? And there's a $500 per day payout that then, after discharge gets voided and you go through the final claim process. But there were no claims submitted during the patient's stay. And again, this process, there's information being requested by Health Choice throughout. They're in the call notes, as I mentioned earlier, one of the notes says that the discharge instructions were provided 6 days after discharge. But then you have the medical necessity report that was submitted in April. It was also submitted with the claim dispute form. All of these state that patient had been discharged. Again, the claim dispute decision even acknowledges that. But instead of Health Choice saying, you've miscoded the claims, you've labeled these as interim claims, patient's been discharged, why don't you change that 2 to a 1? And we're good. There was no other complaints about what information was wrong. But again, that's a separate issue. That's a clean claim issue.
Counsel, how do you respond to their argument, though? It seems like a fair argument that they have hundreds of thousands of these, over 1 million or whatever per year.
They knew she was discharged.
But are you expected, did they have to go to this level of detail on each one?
They have to review the whole UB04 form in order to make a decision.
Fill out their form?
No, they have to review the form to tell them if there's a problem. The legislature set up the process, right? We know what the process is. You've got 6 months to get the claim on file. We did that. That's the only issue before the court. You then have 12 months from discharge to get it clean. The contractor's responsibility is to tell you what the problem with the form is. It's not meant to be a moving target, which is what ended up being the case here. The first clear direction that we heard that, Your Honor, I worked on the case, I was in the weeds. The first time it was even occurred to me that the problem was the claim type was when we heard it at the state fair hearing before the ALJ. We didn't even know that. If Your Honor looks at the record, maybe you thought the same thing, that it's not very clear that, okay, the real problem here is.
What if your client, let's say there are it's not just this case, there's 8 patients successively, and your client miscodes just one number, but 8 in a row, right? Not just one. Does and it's the same dynamic relationship. Does Health Choice have the obligation in 8 different occasions then to pick up the phone or send an email and
Yes.
remind you? Yes.
Absolutely. Opposing counsel brought up a hypothetical that if the claim form was submitted to the wrong payer, I would submit if the patient's name wasn't there or was wrong, patient's number was wrong or something. Maybe there's an argument there, but that's not this case. That's not this case.
So what's the difference, though? Where do you get to say that that's such a big difference that we shouldn't even consider it? When if they've got the wrong patient, they have to correct your patient versus they have to correct whether it's interim or final. Where is that line, and under what authority are they supposed to act? if that's the case.
I don't know where the line is, but we gave them all the information. The legislators made clear, you don't have to submit an error-free form. You don't have to do that. You've got 12 months to reach clean claim status. Now, we weren't able to get there because we were never told the problem. And importantly, and the ALJ found this in her findings, in the claim dispute decision, Health Choice directed MedData, the vendor, to submit a corrected claim, putting all of the services on one claim form. They did that. The call notes demonstrate that. The ALJ found that we sent off the corrected claim and then later said they would not consider it. So even if you consider this clean claim issue, which is not properly before the court, they told us they would not let us fix the problem. All that UMC had to do to comply with the first stage of the claims process was get a claim on file. They did that. There's no dispute about that. The Superior Court does an excellent job analyzing that statute. Initially submitted means getting a claim on file. We did that. That's the only issue before this court. There are certainly several other alternative bases that the court could affirm, and we ask that the court affirm the Superior Court. Thank you.
Thank you.
Thank you. If I may follow up on a few points. Council keeps on stating that there is authority out there that requires Health Choice as a contractor to provide a written notice of denial. And I didn't hear him mention where that authority was. I didn't hear him reference the citation or the statute, and we're not aware of one at any time before needing to issue the notice of decision for a claim dispute. That happened in August. The claim dispute was submitted in July. That was done.
And did it state the factual and legal basis for the decision?
That's the one that I was talking about earlier that said we can't process your bill as claimed. You need to submit everything on one claim form with all dates of service. So that's the first one.
But it did not, but just to clarify, it did not point out the error, the one-digit error.
Again, how do we know that it's an error? How do we know that they're not trying to submit an interim claim?
Well, his point is that you knew in that there was a discharge date. And I know that there's a difference of opinion about whether you received the third one, but we've got a finding that you had to have sent in one form.
So you can submit an interim claim after discharge. It just can't be paid. It is possible to do that. An interim claim is, please pay me $500 a day for this patient, regardless of what happened. No, regardless of what service is rendered. Please pay me $500. It's, again, to use kind of a stark example here, submitting a claim for treatment on a left hand is not the same as submitting a claim for treatment on the right hand. Two different claims. An interim claim is a claim for please pay me $500 per diem per day, regardless of what happens. You don't have to, we don't even know that you have to provide any codes about what was done on those days, just that they were there. Now, a claim for please pay me for this, all services rendered during this hospital stay, that is a different claim. That is a completely different claim. It's one that's processed differently. You've got to provide different information, all of those types of things. Now, they keep on talking about a one-digit error. All of these codes, they're numbers. There's lots of differences by one digit in these. There's lots of differences by names. If you submit a claim for John, that's not the same as submitting a claim for Jim. Those are two different claims. And here, it's two different claims. It's a fundamental difference. They were told, put everything onto one claim form, not 7, put everything onto one claim form, all dates of service, all services rendered, submit that corrected claim. They didn't do it. Simple as that.
What about ALJ finding number 16 that says contrary to the August 21st denial notice indicating complainant could file a corrected claim, Respondent informed complainant that it would not consider any corrected claims.
And as far
Is that
as,
a clearly erroneous finding?
it is.
Have
there
you,
is-
have you challenged that
It-
on appeal? Or in the Superior Court? Because I don't recall that.
As far as, as far as challenging that specific holding, no. But again, this is one of those situations where there is no substantial evidence to uphold that. I mean,
But
there,
you haven't challenged that factual finding.
not specifically. Right.
about
I mean, it
general?
wasn't in, so the notice
You
of.
say specifically, what is that?
So the notice of
Qualifying.
appeal that was submitted in the Superior Court was submitted by them. There wasn't a cross appeal done. And here at this court, we were appealing from the Superior Court's decision. And so we put at issue the issues that were in the Superior Court's decision.
Okay, thank you. Counsel, your time is up. Thank you both for your arguments this morning. We'll take this matter under advisement, issue a decision in due course. We'll take a brief recess to set up for the next argument.
Thank you.